Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section, where we cover current topics in antitrust, consumer protection, and privacy law. My name's John Roberti. I am your host today, and today's topic is, when is doing good bad? Antitrust and social responsibility agreements. There are times when organizations are trying to affect change. And when they do, they want to make that change happen quickly. Now, you can get people to change, but one of the things that's really, really hard is to get somebody to go first and then to get enough momentum so that momentum pushes you and everybody adopts. However, but maybe it's easier for everybody to agree. But if they do, that brings in antitrust, and that's what we want to talk about today. My co-host is Elyse Dorsey. Hi, Elyse.
Hey, John.
So, Elyse, what do we have lined up today?
We have a really interesting topic today. I think you mentioned it's when doing good goes bad. So a big focus for antitrust law is when firms get together to do things, and it can be really pro-competitive. It can help them bring new products to market. It can help them do innovative things. It can also be really anti-competitive, which I think we've covered in a different previous episode on our Curious Amalgam on cartels. If they're restricting prices or output, that can be really bad for consumers. And then there's kind of this third category we're going to tackle today where maybe they want to do something that has social value, but they're coming together to do it in a way that might have effects on prices and output that we traditionally think of in antitrust is not so great. And we're going to dive into like what antitrust approaches to that, how and when the agencies get involved, and maybe how firms can do a little better.
Well, we don't know the details, but I think there's been some reports of an investigation involving automakers in California and adoption of state-level emission standards. Maybe we can use that as a jumping-off point today to talk a little bit about some of these issues.
Yeah, I think that's a great example. There was also recently, I think, Uber drivers were kind of coordinating among themselves to try and raise the prices they were getting paid. So we're seeing this in a few different ways, which I think will be very interesting to discuss today.
And you can go back a number of years where the trial lawyers in Washington, D.C. all got together to try to get their reimbursements up, and that went up to the Supreme Court. And we'll get to this, but I think we'll probably even be able to talk about one of my favorite topics, which is the Norr-Pennington doctrine, or the immunity for petitioning. Well, let's get that. Who's our guest today?
Today we have Melissa Maxman, who we're very excited to have. She was dancing to our opening intro, so no one could see it, but I wanted to make sure everyone knew. It was pretty awesome. She is a managing partner at Cohen Gresser in D.C., and she is also co-chair of the Antitrust Law Section's Exemptions and Immunities Committee. Thanks for joining us, Melissa.
Thanks for having me. I'm excited to be here.
Yeah. All right. So as John was saying, there's a lot of times I think now there's a bigger focus on corporate responsibility lately and an emphasis on getting firms to do the right thing. And there's a little bit of a first mover disadvantage in this kind of area. So kind of talk to us a little bit about some background, maybe. What are you seeing generally, and how does antitrust kind of approach this?
Well, antitrust has been in the news for a variety of reasons. In the presidential election and so on. But most recently, there's been a very high-profile investigation by the Department of Justice Antitrust Division into Ford and Honda and BMW and Volkswagen agreeing with the California Air Resources Board, or CARB, to adhere to stricter standards in California for tailpipe emissions than federal law requires.
So, Melissa, why is that bad?
Or why could it be bad?
Oh, how do you define bad? How do you define good? The Sherman Act on its face, prohibits agreements between competitors in restraint of trade. And reams of paper and trees have died trying to figure out what is restraint of trade in violation of the Sherman Act. Here, the DOJ isn't even saying, we think this is a violation of the Sherman Act, because they recognize it's not an agreement between these manufacturers to fix prices. I'm going to price my car at X and you're going to do it at also X. We're not going to go higher. We're not going to go lower. But this is an agreement that could have impact on the price of cars.
So is it any agreement between competitors that will have an effect on prices? Is that automatically bad? How do you figure this out?
Well, there are a number of ways. Most people have heard about the per se illegality, and that's a naked restraint of trade. It's a restraint of trade. It's a boycott. It's people getting in a room and saying our margins are too low, so let's all agree we're not going to take. You
have an agreement and you're done, right?
Exactly. That's per se.
All right. So kind of like OPEC.
Well,
getting into a room, not subject to the antitrust laws here, but
exactly.
I think that's like a more accessible example. For
exactly,
a lot of people have some familiarity with.
I have a number of clients, and actually my brother, who does a lot of business in China, and he says the Chinese manufacturers get together once a week and set the prices, what they're going to be next week, and it's very frustrating to people who are not in China or in the Western world, who aren't at liberty to do that. But yes.
Okay, so you talked about per se. What if it's not per se?
So the next one down is if it's something that's got maybe pro-competitive, maybe anti-competitive, we're not sure. That's analyzed under something called the rule of reason. And the rule of reason essentially says we're going to put out a balance. We're going to put everything that's pro-competitive about it on one side of the scale, and we're going to put everything about it that's anti-competitive on the other side of the scale. And again, courts have talked a lot about how do you measure it? Are certain pro-competitive things worth more than certain anti-competitive things? And overall, could you come up with a better way to do this? Is there a less restrictive alternative? But ultimately, it's for a court to decide, overall, here are the facts. Is this going to help competition or hurt competition? Now, that gets even more complicated when how do you define what competition is being hurt or helped.
But let's accept the premise, maybe, just for purposes of our discussion, that an agreement like the one we talked about could have an effect on price. Let's just accept that by agreeing to higher emission standards in this, we'll call it hypothetical, by agreeing to higher emission standards, it's going to increase the cost of making the car. And increasing the cost of making the car is ultimately going to increase the cost to consumer. Why isn't that the end of the discussion?
Well, there are three reasons that leap to mind. Number one, is it going to increase the cost to consumer and to the consumers? And if so, do they care? Because some consumers, especially in California, from what I can gather, really care about clean air. They've had terrible problems for decades. So just as I will probably pay more in a grocery store for organic goods because I think it's healthier for me and I can afford it, there are people who will say, I don't care if it goes up. It's worth it for the greater good, and I want my children to have cleaner air. Putting that to one side, this isn't clearly a price restriction. Something who says we're not going to charge more than X or Y, or we're not going to charge below, is what you usually see, X or Y, is a price restriction. This isn't even an agreement on pricing of anything. This is we're all going to try to work to get our emissions down. And I think that part of the reason that these manufacturers wanted to talk to each other is they didn't want to be priced out of the market and let everybody else get away scot-free. Now, what the Justice Department, as I understand, is saying is the process of getting together requires a little bit of investigation into what's motivating you. Is it the price? Is it the ancillary price? Why couldn't you each just individually agree with the California Air CARB to we're going to abide by your rules. We wouldn't be able to investigate anything.
So imagine a situation where instead of, let's not talk about cars for a second. Let's make it maybe even a little bit simpler. Let's imagine somebody is there's a group of ranchers in an area, and everybody agrees that there's too much livestock, and if we reduce the number of livestock, it'll be better for the environment. It'll be more sustainable. So all the ranchers get together and agree they're going to trim their herds by 25%. Something like that is. It seems to me that's even with the best motivation, that's a pretty clear output restraint, and would probably be something that would be problematic almost immediately. Is there something that's? Do you have a different view?
No, but there are cases like that are percolating through the court systems now with eggs and chickens and milk, which was a number of years ago. Those are, I think, easier cases than air emissions, because the car makers are not saying we're going to restrict anything except bad things that we're spitting into the air. I think of it as if all toy manufacturers got together and said, we're no longer going to use anything with lead, or we're all going to make safe toys. It doesn't necessarily impact price. It doesn't impact output. And toy manufacturers already have an incentive to make safe toys, because if you don't make a safe toy, people won't buy them. So basic economic theory says the market is doing its thing. Here, the market isn't necessarily doing this thing, and I think the government is trying to push people into seeing, let's make cars less pollutant. The same way they've encouraged people to recycle.
Yeah, so let's pick up on a little bit of what you were getting to at the end there with the government getting involved. So in John's example, the ranchers did this on their own, but what if they had like their local board or something that they worked with to decide that it was going to be 25% they were going to cut reductions by? Does that change our analysis for antitrust purposes?
Well, that's what's also so interesting about it, because in this case, there's a couple exemptions to the antitrust laws that, again, were either court created or statutorily created to recognize that we still have a constitution, and so you can't limit First Amendment speech by adhering to the antitrust laws. So the doctrine that I think is the most relevant here is something called Knorr-Pennington. There's a case. Knorr was decided in 1961, and Pennington came later in 65, and it created a doctrine that had not been around before, which says that private entities are immune from liability under the antitrust laws when they're attempting to influence passage or enforcement of laws. It's essentially lobbying. Okay. Even if the laws they're advocating for would have any competitive effects or even an improper motive, even if your motive is, I do want lower prices or I want cheaper output, you still, if you're lobbying the government for lower prices, cheaper output, or higher prices, or more output, you're exempt. Now, what falls into Knorr-Pennington and what doesn't, again, a lot of it is highly fact-based. If the First Amendment protects political speech, I can see that which it does, I can see that the car makers here are saying this is political speech. This is our way of showing, of doing, of walking the walk, that we want to be able to make money making cars and also don't want to pollute the environment. We don't want to accelerate climate change. And there's a really interesting quote from Knorr that I actually brought with me. It's upon the First Amendment protection of political speech requires this doctrine because it requires a recognition that the antitrust laws, tailored as they are for the business world, are not at all appropriate for application in the political arena. And again, you've got these butting heads of these things that matter to us, these philosophies that are fundamental to being an American citizen. And how do you sort them out? I think what you're seeing here is a playing out of the federal government against state governments, and that brings in these state action doctrines, and a lot of this gets turned on its head and is a little bit ironic, because the Trump administration has been a champion of federalism concerns, as is the conservative part of the court, and California isn't usually in the position of saying, yes, we want states' rights, because they really don't want other bad things that they think are happening in other states to be a matter of state authority in Alabama or Mississippi. But I do think that antitrust doctrine is malleable, and in some ways, NOR and the state action doctrine were designed to help private actors avoid this kind of situation being between a rock and a hard place, like these manufacturers are now.
I think one of the things that's interesting is, as well, when you think about the regulatory overlay, which, by the way, you're 100% right. That makes it completely different from my livestock example, and but the regulatory overlay here is interesting because we had an earlier podcast where we talked about the California privacy laws, and our expert on that podcast told us that would be de facto the U.S. privacy laws. If the California Air Resources Board standards are adopted by these automakers and done by agreement, that de facto becomes the regulation of the United States. So there's an interesting tension, I think, between the federalism point that you raised and the states' right point that you raised is a very interesting context.
I think you're right, but I also think it's a little bit different. I keep thinking of mud flaps, just law school and the interstate commerce. But as I understand it, part of what the negotiation, and this was a negotiation between the government, and it was initiated by the government with these four manufacturers, had to do with how are we going to make sure that cars that are sold in California abide by our agreements and still allow you to produce maybe cheaper, maybe not cheaper, but other cars that don't abide by that by the California agreement elsewhere. I would hazard a guess that no state in the union would say, yes, please, I want more emissions in my state, more pollution in my state. That being said, somebody not in California may not value the organic food or the lower emission cars the way that I do or people in California do. And you're, again, trying to make sure that Alabama citizens and purchasers of cars, and I don't mean to pick on Alabama, but
seems like everybody does.
I know. Well, yes, I do mean to pick on Alabama. Yeah, I'm very much a Yankee. Can you tell? It seems to me that's what they were negotiating over. And when you dig down a little bit into it, what you see is that some of what they're doing is they're saying, well, California, you want 50 miles per gallon. But if we make more electric cars, we get carbon credits for that. So we can do 45 miles per gallon and we'll still get the credit. And so it's this elaborate administrative scaffolding that has been constructed to try to reduce air emissions worldwide, or at least within the United States. So it's not as simple and easy as we would make it, certainly as any of the political candidates would make it.
Melissa, one of the ways that companies that are under pressure will try to effectuate change is through trade associations and through industry organizations. Talk to us a little bit about how you might think about some of those risks and how you would, if you're in a trade association and somebody is suggesting we should be thinking about maybe agreeing with the regulator around these is that a place where an antitrust lawyer jumps up and starts waving her arms and saying, stop, 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 stop?
It was funny when I was discussing this with a couple of people before I came on to this podcast, and all three of us had different reactions. And they're all three antitrust lawyers. I said I would probably, in these trade associations, you sort of give your little thing in the beginning about how we just want to remind you that we're trade association and we're competitors and we're not allowed to talk about price or anything that would seep into price. You're not allowed to talk about cost of goods, but we want to talk about things like how to make the world a better place, or, will my USB plug into your Dell computer? And I said I probably would say, wait a minute, I just want to remind you here that the antitrust laws apply here. One of the other men that I was talking to said it wouldn't even bat an eye, wouldn't even raise a red flag for him. And the third said he would probably try to divert the discussion elsewhere and give a much more fulsome, structured approach to how these people should be talking about it. So you had everything from maybe yes, maybe no to, oh, this is a problem too. I don't see the problem. And that's three experienced antitrust lawyers who we all like each other. We're not competing. We're on the same side. So I don't think that's an easy one.
Melissa, so maybe could you give us some tips if you were an industry organization and you wanted to try to effectuate change, but you weren't terribly interested in being part of an antitrust investigation or an antitrust lawsuit.
That's at the top of my list.
What you're looking for.
What could you do to try to limit that risk?
Acting unilaterally.
What do you mean by unilaterally?
Okay. If you are acting on your own, you're not talking to anybody else about what you want. And this is a mainstay of all horizontal and vertical trade. Acting unilaterally doesn't raise antitrust concerns unless you're a monopolist, but that gets into a whole other Section 2 problem. So you want people to be making their own decisions as much as possible. The problem is the world is so interconnected. In the car sphere, I want to be able to go plug to get gas, put gasoline in my car that works in my car, no matter whether I go to Citgo or Shell or Lukoil or whatever they are now. And so there have to be standards that everybody agrees on. The joke I always use with clients is you don't want, in the medical arena, you don't want your doctor to say to the nurse in an operating room, get me a scalpel. And he goes, no, not that scalpel. I wanted the big one, or the littler one. And so there have to be things that people agree on, even as they compete, so that commerce continues to percolate along and people can do what they need to do and go from place to place and plug in their computers and operate safely in different operating rooms around the country. The more unilateral you are, the less scrutiny you're going to draw to yourself. Also, the more you stay away from prices, because what we're talking about here is really cost of producing the goods, not what they're selling them at. I believe that in this case, the Noor-Pennington doctrine probably would apply. I mean, there's some cases that talk about, like North Carolina Dental, which was recent, that if the body is not an actual governmental body but a quasi-governmental body, then it might not qualify for Noor-Pennington exemption. So, but even if it doesn't, even if the California Air Resources Board is not a governmental organization, I still, if I were analyzing this and I were a judge, I would probably come down on rule of reason. It's not anti-competitive enough.
So Melissa, I want to go back to something you said at the beginning. You talked about how do you measure social good, and I have to say, I think a coal miner in West Virginia would view environmental regulations very differently than a lobster fisherman in Maine.
And that's exactly what this all really comes down to. That's where the tension is. Being as embracing as you can of the Trump administration's, of AAG Del Rahim's approach, he doesn't want California to be the tail wagging the dog. He doesn't want the California regulations to be required sotto voce, sliding them in because car makers now have to just make cars that are more expensive or that have better air emissions and force the decisions on other states. Now, obviously, in this political climate, there are lots of people who feel very differently about climate change and air emissions and how bad it is and whether humans can create it or not. And I'm not going to get into that. What I am going to point out is that that's the reason we have a Congress. Congress determines what is good public policy. Now, do we always agree with what Congress says? No. In this political atmosphere, you've got a state legislature coming up against the executive branch of the federal government, and that's why we have checks and balances. I don't know where we go from here. I think it's going to be worked out one by one, little by little, but I don't have any clear crystal ball at this point.
Yeah. And I think, like you said earlier, antitrust isn't necessarily the solution to all of our problems, although it does kind of run into a lot of them in several ways.
Exactly.
Well, Melissa, it's very clear you're very passionate about antitrust. What is it that you like so much and enjoy about your practice?
I'm one of these people who went to law school thinking she was going to make a difference in the world. I want to help people. The thing that interests me about antitrust is that it does address social policy. And on a personal level, how well I lawyer can impact the outcome. On a bigger picture, it's not all about me level, I think there's a tension between the law and public perception, the court of public perception. And I keep going back to recycling, or actually gay rights. When something becomes apparent that the world has moved or Americans have moved, the law follows along. I always joke that litigation, and especially antitrust litigation, is a lagging indicator. This is one area where we can be on the forefront.
Great. Well, I think for our listeners, we'd like to get to know also a little bit more about you outside of the law. So could you tell us something interesting about yourself, or maybe something that people who only know you professionally might not know?
Well, I was the Democratic candidate for state senate in Pennsylvania's 26th congressional district in March of 2001. Now,
wow.
It was before 9/11, so the world changed. But I was in a very Republican area, Delaware County, Pennsylvania, and it was right after the Bush-Gore fight, and which wasn't decided until January. And my state senator, who was the president of the state senate, was sent to prison for taking kickbacks.
Ooh.
And there was a special election, and Ed Rendell and Bob Casey were running against each other to be the new Democratic gubernatorial candidate. And both of them came to me and said, "Look, Melissa, I was 40 years old. I lived in the district. I had a background in being politically active, and I was a former federal prosecutor." And so I said, "All right." And my wonderful law firm gave me a leave of absence, and I raised and spent over $1 million in 2 months. And I still lost badly, but I beat the spread. The district was 70-30 Republican, and I only lost 60-40. But it was at the time, since it's been surpassed, but at the time it was the most expensive state senate race in Pennsylvania history.
Wow.
Well, congratulations.
Yeah.
Not really.
And I think now is the time where we go to our last segment, which is called The Curious Hat.
And now it's time for the Curious Hat.
Melissa, this is our final segment. I have in my hand a hat that has a series of index cards with questions on them. I'd ask you just to choose one. Don't choose the one on top. That's good.
I want one in the middle.
Yeah, one in the middle. Great.
Okay.
I'll turn. Okay, good. Melissa's chosen question number 20, which is, who is someone that you look up to or greatly admire?
Just one person?
I think if you want to do two, I think we probably have time for that.
I'd have to pick my two mentors. One is Congressman Tony Coelho, former Congressman Tony Coelho. He was a congressman from California. He was the Democratic whip, and he was the head of the Democratic Congressional Campaign Committee when I worked there back in the 80s. And the other is my legal mentor, a guy named Mike Bailson, who's now a federal judge in the Eastern District of Pennsylvania. He's now a senior judge, and they both just had moral compasses and one's a Democrat, one's a Republican, so it's not, they just both taught me a great deal about how to live my life, even beyond my career.
Well, so how do you find a good mentor?
Oh, my goodness. Some of it is luck. Some of it, there are people who think that you make your own luck. I think you keep your eyes open. I started the Democratic Congressional Campaign Committee as the receptionist in 1980. There were 7 employees. We were up on North Capitol Street, and I answered the phone, and it was one of those rotary phones that you had to push the little knobs to say, sir, so-and-so's on the phone. And I worked hard, but I kept my eyes open for people who wanted to bring me up behind them. And the same thing happened, I think, when I was in the U.S. Attorney's Office under Mike Bailson, when he was the U.S. Attorney for Philadelphia, and kept my eyes open for opportunities. And he ended up taking me with him back to his law firm when he left. I'll tell you, one other person who I admire a great deal is Midge Rendell, Third Circuit judge. And she was my partner at Duane Morris years and years ago in Philadelphia. And she used to say, she said that she got this from someone else at Duane Morris, but that the key to success is surrounding yourself with people who want to see you succeed, who measure their own success in part on whether or not the people around them are also succeeding. And I've tried to live that.
Melissa, thank you. And I think that is the end of our Curious Amalgam for this week. Thanks for joining us, and we'll see everybody next week.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.org. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.